plaintiff's amended complaint.
Good morning, Judge.
Your Honor.
Let's go with the plaintiff
Julian.
first.
Sure.
Good morning, Judge. It's Edduard Prince, plaintiff, pro se.
Good morning.
And good morning, Your Honor. Julian Jackson Fannin from Duane Morris on behalf of defendant Seaboard Marine Limited Incorporated.
Okay. All right. Go ahead, sir. It's your motion.
Yes, Your Honor. So we are here today, and just brief background on the genesis of this case is that the defendant failed to hire the plaintiff for a temporary messenger driver position at the Port of Miami at its 85-acre facility there in August and September of 2019. The plaintiff has now twice tried to plead race discrimination and national origin discrimination claims under the Florida Civil Rights Act against Seaboard. However, he has now yet again failed to actually state a cause of action predicated on a failure to hire. The elements, of course, are that he has to allege that he's a member of a protected class, he was qualified for and applied for the position, and he was not hired despite the qualifications, and that the position was either filled by a person outside of his class or that it remained open. What is that issue here, Your Honor, is that the plaintiff has failed to allege any of the qualifications necessary for the position, and that he actually met those qualifications for the position. In fact, he has a conclusory assertion that despite plaintiff's alleged qualifications, he was not hired in paragraph 12 of his amended complaint. But more importantly, in paragraph 15 of the amended complaint, he says that he spoke with a particular employee at Seaboard who explained to him the qualifications was that he needed to fluently read, write, and speak Spanish for the position because the position is responsible for transporting crew members from various vessels and vendors and employees, and they all predominantly speak Spanish. So that was a requirement of the position. The plaintiff goes on to allege that he was not fluent, and that this was, in fact, the reason that plaintiff did not receive the driver messenger temporary position. And so by virtue of that allegation itself, he has pled himself out of his claim because he's not qualified for the position. He did not meet the qualifications for the language requirements of the driver messenger position. Beyond that, Your Honor, in terms of national origin discrimination, the only national origin that he's alleged in his complaint is that he is American, not that he certainly has not been discriminated against because he is American, nor has he indicated anywhere in his response to our motion that having a bilingual requirement for a job position constitutes national origin discrimination or race discrimination for that matter. The only allegation that he's included now in his amended complaint, either in his substantive counts, count 1, which is the racial discrimination, and count 2, which is the national origin discrimination, he's selectively incorporated certain portions of his preceding allegations in there. But the only allegation that he asserts is that he had a feeling, plaintiff had a strong indication that he didn't receive the position because he was African American. And that was in paragraph 14. So in all, Your Honor, plaintiff's amended complaint has yet again failed to allege race discrimination or national origin discrimination under the civil rights.
Like you said on line 14, that he says he didn't receive the position because he was African American. He states it right there. You said it yourself on line 14. He states that he didn't receive the position. It reads in paragraph 14 that he did not receive the position because he's African American. I think that's right there. He's given the reason.
Okay, well, if that's the case, if we want to say that he has pled that was the basis for that, he still hasn't pled the qualifications for the position.
Okay.
Nor has he pled that he met the
counsel, at this time, I'm going to deny the motion without prejudice. You may very well, Mr. Prince, I don't require a response from you. I'm denying the motion. So at this time, you may very well prevail on a motion for summary judgment, counsel. But at this juncture, I think he meets the bare bones, and so I'm going to deny the motion. Counsel, if you would be so kind as to drop the order for today, make sure you title it correctly, put that it was heard on today's date via Zoom remote conferencing, put your name as the attorney that appeared on behalf of your client, and put that Mr. Prince appeared by name at pro se, Motion is denied without prejudice. And like I said, you may very well prevail on a motion for summary judgment, but at this time I'm denying the motion.
Thank you, Judge.
Thank you, Your Honor.
All right. Thank you. Take care, both of you.
Good day.
Thank you.
Next one is Robert Duggar et al. Versus Jasmine Enterprises Corp. et al. Case number